Okay. Can you please remind me of our previous session? What was our earlier discussion? We completed the discussion with respect to Schedule 5, Part 1. So now in this class, we are going to discuss Schedule 5, Part 2 with respect to remuneration limits. Remuneration limits, maximum remuneration for directors, including MD, WTD or manager. So let's quickly recall the previous session, Schedule 5 Part 1. I hope all of you remembered that 4 points. Schedule 5 Part 1 talks about the eligibility criteria with respect to appointment for the position of MD, WTD, manager. Okay, so first of all, we need to check whether that person, that intended person, is in compliance with Schedule 5 Part 1 or not. We have to check that point first. So in Schedule 5 Part 1, 4 points are there. Just a minute. In Schedule 5 Part 1, 4 points are there. First point, no imprisonment, not even a single day is allowed. Forget about 6 months and 1 month. That is a different scenario where you have studied in 164.1 disqualification criteria, less than 6 months, no disqualification, more than 6 months up to 7 years, 5 years disqualification, imprisonment for a period more than 7 years, lifetime disqualification. That is the disqualification criteria for a normal director. Now we are talking about the eligibility criteria of MD, manager, WTD, who is going to vest substantial powers over the company. That is why strict rule is that you should not went under imprisonment, not even for a single day, according to 16 acts. Some other books are containing it as 19 acts, but what is the standard criteria for us? Institute book. In your institute book, ICMA released book, it has clearly mentioned as 16 acts. That is why we have to follow that criteria only. Sir, what are all those 16 acts? None of your business. You don't need to remember it. GST, Central Excise, Customs, Income Tax, FEMA. There are a lot of acts, but you don't need to remember. So, imprisonment along with another point is also there. Penalty provision. You should not go under, you should not be penalized 1,000 or more. If there is a penalty to the tune of 1,000 or more, you are not in compliance with Schedule 5 Part 1. Schedule 5 Part 1. Okay. Second one, there is an act. There is an act. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. In simple, we can call it as Coffee Posa. Coffee Bosna, tea Bosna, idele. Idi. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. COFEPOSA. If you are unable to remember that long name, you can simply remember according to this name. COFEPOSA. Coffee Posa. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. You should not be detained under this act. Detention is enough. If you are detained under this act, we can say that you are not in compliance with Schedule 5 Part 1. This is second point. What is the third point? Age limit. So age 21 to 69 actually. 21 to. So if you are underage or if you are overage, we can say that you are not in compliance with Schedule 5 Part 1. If you intended to appoint 19 years age person, or 18 years person or 20 years person as MD or 71 years person as MD, then we can clearly say that that person is not in compliance with Schedule 5 Part 1. And last but not least, President of India. Very good. Resident of India. He must be resident of India. If any of the mentioned conditions are not satisfied, he's disqualified, right? He's disqualified to act as MD or manager or WTD, right? Is he disqualified? He is not at all disqualified, but we can say that he is not in compliance with Schedule 5 Part 1. If that person is not in compliance with Schedule 5 Part 1, what we need to do? We have to take the CG approval. Excellent. We have to take the CG approval. Through which form? MR2. Within 90 days from the date of appointment. You can even obtain the approval from CG even before appointment also. That is the best thing to do. Why it is the best thing to do? Why? Because there is another form which contains days limit also. MR1. MR. Just after the appointment of MD or WTD or manager, you have to intimate to ROC through MR1 within 60 days. Within 60 days. This is the important provision. And you should appreciate the difference between MR1 as well as DIR12. Both are different. DIR12 talks about whatever the changes with respect to directors in the company. But MR1 talks about only appointment. That too, that appointment of any director? No, appointment of only 3 persons. MD or WTD or manager. That's it. So, which form has narrow scope and which form has wider scope? DIR12 has wider scope and MR1 has narrow scope. It will be used only in one scenario, appointment scenario. That to appointment of which director scenario? MD, WTD or manager scenario. That's the only requirement. And if you are considering a position, if you are considering a person for the position of MD or manager or WTD, along with section 164 disqualifications, 2 more disqualifications are also needs to be considered. Yes, that person should not suspend payment to the creditors, or that person should not enter composition scheme with creditors. That is point number 1. And another point is also there. What is that point? Imprisonment. Imprisonment for a period of 6 months or more. There is no hard and fast rule that imprisonment should be levied as per that 16 mentioned acts. It may be under any act. It may be under Motor Vehicle Act. It may be Indian Marriage Act. Whatever the imprisonment it may be. According to which, any act we have to consider in this point. Whereas in this first point, we have to consider only penalties and imprisonment up to only according to 16 acts only. Whereas in that additional disqualification, 6 months disqualification is there. That 6 months disqualification, that 6 months imprisonment may be levied under any of the act. Then he will automatically disqualified for lifetime. Okay, so that is all about Schedule 5 Part 1, which we have covered in yesterday's session. And one more thing, usually the appointment of MD or WTD or manager will be done by whom? Members, shareholders. That is the ordinary business, right? 4 points, ordinary business. One of that 4 point is appointment or reappointment of directors. So usually the directors will be MD or manager or WTD will also be appointed by members only. In which meeting? Members will come only in one meeting. General meeting. It may be AGM or EGM. Our members are going to participate in board meeting? But then why confusion? Only one meeting. GM. General meeting. Maybe AGM or EGM. So let's carefully analyze this point. MD or WTD or manager. Let's check whether those persons are in compliance with Schedule 5 Part 1. Sir, yes, they are compliance with Schedule 5 Part 1. Okay, no problem. Then, in general, members will appoint MD or WTD or managers in general meeting. True. As and when the appointment has been done, you have to intimate to ROC through MR1 within 60 days. Are we clear? Clear. For example, MD or WTD or manager, the intended persons are in compliance with Schedule 5 Part 1. Schedule 5 Part 1 is happily complied. But members got no time to appoint MD or WTD or manager. Or members has delegated the responsibility to Board of Directors. Then who will appoint? Board of Directors will appoint. In which meeting? Board meeting. In board meeting, what kind of resolutions will be passed? Only one resolution, that is board resolution. And if a manager or MD or WTD appointed by board resolution, subsequent ratification is required by members in general meeting. Is there any time limit? No, no time limit. Whatever the meeting they are going to hold within 1 month or 2 months or 5 months or 6 months, in next meeting, the act is saying next meeting. In how much time next meeting should be convened? No hard and fast rule. No specific rules with respect to Companies Act. So, after board resolution, which resolution is required? Ordinary resolution. This is ratification. This is ratification. Ratification means validating the act done by Board of Directors. Yes, you have done it in a right way. If shareholders are against with the decision of BOD, they will simply reject it. If shareholders reject it, the so-called appointed person, MD or WTD or manager, has to vacate the office immediately. Clear? Clear? For example, if members validated the act, members ratified the act, then what will happen? The appointment is a valid appointment. Appointment is a valid appointment. And after passing board resolution within 60 days, same point, MR1, you have to intimate to ROC through the file, through the form MR1 within 60 days. Next point, if Schedule 5 Part 1 is not complied, then board resolution plus generally it will be ordinary resolution, but now it is special resolution. Why special resolution? Why? Because that person is not in compliance with Schedule 5 Part 1. So what is the necessity for your company to appoint that kind of disqualified person, not disqualified, but that kind of a non-compliant person as MD or WTD or manager? That is why no ordinary resolution. In this case, special resolution is required. And along with special resolution, CG approval. CG approval, MR2, how many days? 90 days. Is there any time limit for central government to give the approval? No specific time limit. Central government may give approval generally within weeks, few weeks. In some cases, it might got extension also. It might got extended also. Clear? So this is all about our yesterday's discussion. And one more point we have also discussed. An MD or manager or WTD can be appointed for a maximum tenure of 5 years at a time. It can be extended up to n number of years. But in a single appointment, the maximum allowable tenure is 5 years. 5 years. And you can renew that agreement, but only before 1 year. Sir, I wish to renew my MD appointment, but 2 years are left for expiry of the agreement. Can I do so now? No, I can't do so. I can do it so only before 1 year from the expiry of that employment agreement or contract, whatever it may be. Okay. So these are the points which we have considered in the covered in the previous session. Now we are going to complete remuneration. I hope you got the clarity with respect to what we are going to talk and what we have already completed the discussion. Clear? Perfect. Anybody is having any sort of doubts? Clear? No S. Very good. Next one, remuneration of MD, WTD, manager. If we completed the discussion with respect to this remuneration in this topic, 98% of your syllabus, I mean not syllabus, chapter, directors and KMP chapter is completed. Our next session will be on probably Monday. Monday we are going to discuss a small session, KMP, and BC topics are also there, right? 184 we completed. POI, particulars of interest, we completed. BC topics are there. 185, loans to directors, as well as last one, compensation for conflict of interest. Conflict of interest. So this is the overall structure, right? We completed this one, this one, this one. Now we are going to complete this one, and powers of duties are also we are going to complete in this topic. Hardly 2 minutes discussion. This is powers and duties. You can study on your own also. Why? Because general contractual obligations in Indian Contract Act is their duty to act in good faith. That kind of duties will be entrusted with board of directors. You can study on your own also, but no, nothing to worry. I am going to discuss in this class only. And after that, only the leftover topics will be KMP as well as B and C. A completed, POA completed. B means loans to directors, C means conflict of interest. Just half session is enough, but we are going to complete in Monday session. No hurry. Clarity among the subject is important. There is no rush, right? Today's date is July 11th. If you are able to complete board meetings and procedures, 50% of Companies Act is completed. 50. Sir, how can you say that just after completion of 2 chapters, we have 11 chapters in Companies Act? But if you are able to complete that 2 chapters, 50% of Companies Act, I am saying, not corporate laws. Companies Act 50% is completed. And whatever the remaining topics are all very short topics only. Nothing to worry. Okay. Now, let's quickly discuss Schedule 5, Part 2. Schedule 5, Part 2. Sit properly. Your attention is much needed in this discussion. So, I hope you are going to participate actively in this discussion from now onwards. Okay. Schedule 5, Part 2. Part 1 already completed, right? Part 1 talks about appointment. Now Part 2 talks about remuneration. After appointment, what you need to do? You have to pay, right? That is what we call remuneration. So listen carefully. Just a minute. Schedule 5, Part 2. Part 1 completed with respect to appointment. Now we are discussing Part 2. In Part 2, there are 2 sections. Section 1, Section 2. Section 1, Section 2. Schedule 5, Part 2 comprises of 2 sections. Section 1, Section 2. Schedule 5, Part 2, Section 1, Section 2. In Section 2, there are 2 lists. List A, List B. Listen carefully. You are going to have crystal clear clarity after the completion of this session with respect to remuneration also. Appointment understood, right? Understood, right? Listen carefully. Schedule 1 talks about remuneration of directors. I am not talking about MD or manager or WTD. I am talking about directors. What is the difference between what is the difference between MD, WTD, manager and directors? Which one is the vast term? Directors is the vast term. In directors, MD or WTD or manager is a part and parcel of directors. Directors comprise of so many directors, executive, non-executive, independent, small shareholder, whatever it may be. Listen carefully. Schedule 1 talks about remuneration of directors if the company is in adequate profits. Company is in adequate profits. It means company is having money to pay the remuneration to directors. Company is having money. Lot of profits are there. Yesterday TCS announced the results, right? TCS profit is how much? Have you studied? TCS profit per in this quarter is 12,706 crores. 12,700 crores. Not rupees. 12,700 crores. Previous quarter, the profit is around 12,050 crores, somewhere around 12,000 crores, odd figure. Now the profit has been jumped by 700 crores. Incremental profit, that is. Okay, so listen carefully. So if the company's situation is like this, company is in adequate profits to pay off the remuneration to directors. Company is in adequate profits. Now, there are certain limits with respect to maximum remuneration. Sir, what are those limits? I will write here. Section 1, right? In section 1, what is the case? Company is in adequate profits. Listen carefully. The maximum remuneration allowable for all directors is 11% of net profits of the company. 11% of the net profits of the company. Calculator is there, right? Say for example, calculate 12,700 into 11% is how much? 1,397, around 1,400. So in case of TCS, the maximum remuneration for allowable directors is 1,400 crores. That too, this profit belongs to quarter, not per annum basis. Into 4, approximately. Around 5,000 crores. That is the maximum remuneration allowable to directors. Whether the company is paying that much amount to directors or not, I don't know. But that is the eligible criteria. Maximum remuneration, not minimum remuneration, maximum remuneration. 11% of net profits. Is every company will be in profits only? No. Some companies will be in losses also, not in adequate position to discharge the remuneration is also. That is why those concepts which we are going to learn in section 2. Currently we are engaged in the discussion of section 1. What is the case of section 1? Company is in adequate profits. Maximum remuneration for all directors, including everyone here. Executive, non-executive, MD, WTD, manager, what not, include everyone. How much? 11% of net profits. 11% of net profits. Sir, independent director is there, sir. We are giving sitting fees for independent director, sir. Shall we include sitting fee also? Listen carefully. Listen carefully. Don't be engaged in premature evaluations. First of all, remuneration means salary and perquisites excluding sitting fee. Excluding sitting fee and excluding professional fee for professional services also. If director is in individual capacity rendering some services on professional basis, no need to write. I have already written here. S fee into, S fee means sitting fee, not to be included in the remuneration, and professional services, director on his individual capacity rendered some services to company and charging some 5 lakhs or 10 lakhs as his professional fee. We are not going to include that. in remuneration. And reimbursement of expenses also we are not going to include in remuneration. What is the sole purpose of reimbursement of expenses? What is mean by reimbursement? You have incurred some expenses on official basis and you are getting it back. Why we need to include that reimbursement in remuneration? So these three points we should not include. Sitting fee should not include. Fee for professional services rendered in individual capacity to the company should not be included, and reimbursement of expenses also should not be included. Are we clear so far? Remuneration includes only salary and perquisites. So when it comes to independent director discussion or any other nominee director discussion or any other small shareholder director discussion, if you are going to give sitting fee for them, you should not include in that 11%. Sitting fee should be excluded from remuneration. And according to Companies Act 2013, maximum cap for sitting fee is there, 1 lakh per meeting. 1 lakh per meeting. If you attended 7 meetings, 7 sitting fees, maximum 7 lakhs. Clear? It has no relevance with profits, including remuneration. Okay. Independent director, that is a different case. Now, if I include it, it will tend to confusion. Okay. So, sitting fee we should not include it in the remuneration. What we need to include? Salary and perquisites. And any other performance related bonus, PBP, performance based payments. What is PBP? Performance based payments. If profit has been increased by this much, you are going to get this much increment. This is called PBP, performance based payment. These are also included in remuneration. But what should not be included in remuneration, that is the important point. That's why I have clearly mentioned here. Sitting fee, professional services fee, as well as reimbursement we should not include. Coming to our original discussion. We are talking about section 1, right? Section 1, what is the case? Company is having adequate profits. Whenever the company is having adequate profits, it can give maximum remuneration of 11% of its net profits to directors. Maximum. Okay. Sir? You said 11% to all directors, right? Who are the crucial directors among all directors? MD or WTD or manager. These are the crucial persons. Let's answer my question. Whether this combination is possible? MD plus manager combination possible? No. MD plus WTD? Yes, possible. WTD plus manager? Possible. So, in this way, at a time, all these 3 persons will not be there in company. These are the allowable combinations. For a single company, it should not be having MD and manager at a parallel time. It is not allowed as per Companies Act. 1 person rule. We will call it as 1 person rule. 1 person rule. I have already covered in earlier sessions with respect to this discussion. Okay, right. Listen carefully. Sir, you said that 11% of net profits is allowable to all directors, right, sir? But who are the real hard-working directors, sir? MD, WTD, manager. These are the real gems behind real gems behind the performance of the company, right? That is why there is a sublimit. What is that sublimit is 5% of net profits for MD or WTD or manager. Listen carefully. Listen carefully. If there is only single person for it, that means only one MD is there, or only one WTD is there, or only one manager is there, only one single person, only one MD, or only one WTD, or only one manager is there, then the sublimit is 5% of net profit. Sir, we have multiple persons, sir. Multiple persons means 1 MD and 3 WTD. Allowed? Allowed? Yes, 100% allowed. 1 manager and 3 whole-time directors, or 1 managing director, 1 MD, or 3 or 4 whole-time directors. Multiple persons are there, sir. Then what is the sublimit, sir? 10% of net profits. 10% of net profits. Are you able to appreciate the difference between these 3 cases? What is the first case is saying? Whenever a company is having sufficient profits, it can give maximum 11% of its net profits in the name of remuneration to all directors. This is applicable to all directors. Clear? Everybody clear? First point clear? 11% applicable to all directors. Whereas second point talks about 5% if there is only single person. That single person may occupy the position of MD. That single person may occupy the position of WTD. That single person may occupy the position of manager. Only single person is there. Actually, this is highly impracticable. That is why because generally any small company is having multiple directors, multiple MD and WTD and manager. That kind of combination will be there. Why? Because MDs or WTDs have lot of duties to discharge. So that is why this is not a generally acceptable practical case, but being there is a rule, we have to study it properly. Okay, if there is only single person, we have to give maximum 5% of net profits. If there are multiple persons, 10% of net profits. 10% of net profits. What is the 11% case? All directors. What is the 5% case? Companies having only single person as MD or WTD or manager. What is the 10% case? Companies having multiple MD or multiple MDs, not multiple persons occupying the position of MD, WTD or manager. Okay. Usually MDs, WTDs or managers, they will actively engage in the business activities, right? Actively engage in the day-to-day activities, right? Those directors who are actively engaged in the day-to-day affairs will be called as come out. Very good. Executive directors. First of all, we spoke about all directors rule. Next, we spoke about executive directors remuneration limit. There must be non-executive directors limit also there, right? Right. Non-executive directors also there should be some sublimit, right? So that limit is 3% of net profits if there are no MD or WTD or manager, and 1% of net profit if there is MD or WTD or manager. Why? Why? Because if there is no MD, no whole-time director, no manager, workload has to be shared by whom? Non-executive director. That is why 3% limit is there. If there is MD, if there is WTD, if there is manager, those persons are there to discharge the workload, right? What you are going to do? Your workload will be very small. That is why your limit is only 1% of net profit. Are we clear? End of the discussion with respect to section 1. No more sublimits. You can relax. Some students are thinking that this person is keep on adding the sublimits 11, 10, 5, 1, 3 completed. You can relax. So everybody got the clarity with respect to the sublimits as well as original limits. What is the original limit? 11% applicable to all directors. After that, sublimits are there for executive directors. We should not call them as executive directors. For your understanding purpose only, I have used the term executive directors. We should call MD, WTD, manager. So if there is only single person, 5%, multiple person, 10%. After completion of executive part, we have to come non-executive part. What is the sublimit for non-executive part? If there is no MD, lot of work will be there for non-executive directors, that is why 3%. If there is MD or WTD or manager, workload will be less, that is why only 1%. Clear? Sir, company wishes to give more remuneration to directors, sir. Company wish to exceed these limits. 11% limit, 10% limit, 5% limit, 1% limit, 3% limit. Company wishes to exceed these limits. It can happily do so. Why? Because company is in profits, na? Who is the backbone of the management of company? Directors, right? So we have to reward them properly, right? That is why companies, if company decided to give more than remuneration with respect to these sublimits, it can do so by passing a simple ordinary resolution. Sir, why ordinary resolution? Company is in profits, right? Company is in profits, right? So what is the headache for the company if say for example, if special resolution, in which cases special resolution is required in case of complicated decisions? Is it a complicated decision? Company is pouring with profits. Company has lot of profits. Who is the reason for these profits? Directors. That is why no more special resolutions. Being the company is in profits, it can increase that sublimits by passing a simple ordinary resolution. And no more central government approval also not needed. Nothing. If company wishes to give 20% of net profits to all directors, it can do so by passing a simple ordinary resolution. So I hope you guys got the clarity with respect to section 1. Section 1. Clear? Section 1 talks about which case? Company is pouring with profits. Company has adequate profits to give the remuneration to directors. These are the sublimits, and company can happily increase that sublimits by passing a ordinary resolution. Are you guys going to remember this topic for a longer period of time? Very important from practical question point of view. Clear? Let's talk about section 2. Section 2. What is section 2? This one. What is section 2? Oh, just a minute. What is section 2? In section 1, company is having lot of profits. Obviously reverse. Company has no profits, or company is suffering with losses. Company is suffering with losses. Now what we need to do in order to give the remuneration to directors? We have to follow effective capital method. We have to follow effective capital method. Sir, why list A, list B there? I'm going to tell. Please listen carefully. First of all, let's quickly understand about what is meant by effective capital. Effective capital. Effective capital is nothing but, listen carefully. Effective capital is nothing but paid up share capital plus securities premium plus reserves or surplus plus loans or debentures or deposits which are going to mature more than 1 year. That is long-term loans, long-term deposits, long-term debentures minus investments minus accumulated losses minus one more preliminary expenses. Preliminary expenses. This figure outs to effective capital. Effective capital. This is the calculation behind effective capital. Effective capital. Understand? Paid up share capital plus securities premium plus reserves and surplus. In reserves and surplus, revaluation reserve will not be included. Why you also? I think you know the meaning of revaluation reserve. Revaluation reserve is a fictitious reserve which is not there in reality. Generally, revaluation of fixed assets is the, whenever we calculate revaluation of fixed assets, we'll come up with revaluation reserve. It is a fictitious reserve. That is why we have to exclude those kind of reserves. So, paid up share capital plus securities premium plus free reserves plus long-term borrowings minus investments made minus accumulated losses minus preliminary expenses. Being we are not considering fictitious reserves, we have to exclude fictitious assets also. That is why preliminary expenses we are excluding. Preliminary expenses fictitious asset, right? At foundation level, you might have came across what is a asset and what is a fictitious asset. Now I'm not going to tell about all those things. So this is the calculation behind EC. What is EC? Effective capital. Sir, we found out the effective capital, sir. What we need to do? You have to check the limits. What is the allowable limits means? If the effective capital is negative, some companies, why in section 2, what kind of companies we are considering? Companies which are in losses. Companies which are in, if accumulated loss is a big amount, we might experience a negative figure in effective capital. It's not a big deal. Take a sick company balance sheet. Sick company. Best example for sick company, Hindustan Zinc Limited is there. Download its financials from internet and calculate this effective capital. You found out a negative figure. Okay. So, if the effective capital is negative to 5 crores, negative figure to up to 5 crores, negative figure to 5 crores. Allowable remuneration per person per annum is 60 lakhs. Allowable remuneration per person per annum. Per person means per director. Per person per annum is 60 lakhs. Okay. If it is the case of non-executive director means workload is more or less? Less. That is why we have to consider 12 lakhs. 12 lakhs per person per annum. This is for executive director. And if the effective capital slab is 5 crore to 100 crore, 5 crores to 100 crores, effective capital came up to 5 crores to 100 crores, somewhere around 6 crore, 8 crore, 80 crore, like that. Remuneration, maximum eligible remuneration is 84 lakhs per person per annum. Per person per annum. And for non-executive people, it will be around 17 lakhs. How much? 17 lakhs. And 100 crore to 250 crore. 100 crore to 250 crore. The maximum eligible remuneration for a person per annum is 120 lakhs. And here it is 24 lakh. 24 lakh. There is no rocket science behind it. Simply 1/5 of this figure is non-executive remuneration. 60 lakhs by 5, how much ma? 12 lakhs. 84 by 5, how much ma? 16.8, not 17. 16.8. On rounding off basis, we have to include 17. Next, 120 lakhs by 5. 24. Okay, next one. Sir, listen carefully. Sir, the effective capital came up to more than 250 crore, sir. More than 250 crore. Then maximum allowable remuneration per person per annum is 120 lakh plus 0.01 percentage of paid up share capital greater than 250 crore. Say for example, paid up share capital is 350 crore. Paid up share capital is how much? 350 crore. So what is the paid up share capital beyond 250 crore? 100 crore. So out of 100 crore, 0.01 percentage. Somewhere around it will become around how much? 100 crore. Do you know how many zeros are there in crore? 7 zeros. 100 crore mean 9 zeros. 100 crores into 0.01 percentage, how much? 1 lakh. 1 lakh. There is a calculator. Shikhara. Okay. Proprietor name. Okay. Institute name. Okay. Next one. Listen carefully. So that is why 0.01 percentage of paid up share capital exceeding 250 crore. And here also same thing. 24 lakh plus 0.01 percentage of paid up share capital exceeding 250 crore. Clear? So these are the eligible maximum remunerations eligible to executive directors as well as non-executive directors. Sir, we wish to increase this limit, sir. We wish to increase this limit, sir. In previous case, being you are in profits, it is easy to increase the limit by passing which resolution? In the previous case, by passing a simple ordinary resolution, you have increased the limit. Class up to 815 or 830? I can't trust you guys anymore. I will check by myself. 7 to 830. Okay, we can comfortably complete this topic. Okay, we'll do one thing. After completion of remuneration, we will halt this session. No more powers and duties. Okay, why? Because no more and more sublimits are there. You have to digest the subject properly. Clarity is more important. So how much quantity we have completed, that is irrelevant. I can complete this entire director's chapter in 40 minutes marathon session also. Not a big deal. But understandability, for that is the beauty of regular coaching. Slow and steady. Okay, so come to the topic. Listen carefully. This is the maximum remuneration, but shareholders intended to increase that remuneration. In section 1, being the company is in profits, it is quite possible for shareholders to increase the remuneration by passing a simple ordinary resolution. But now, what is the case with section 2? Company is in losses. Company has not adequate profits to give the remuneration. Company is in losses. That is why I hope you got the clarity. Which resolution? Special resolution. Which resolution? Special resolution is required to increase that limit. Sir, how much we can increase, sir? You can increase up to 2x by passing a special resolution. You can double the remuneration. That means 60 lakhs become 120 lakhs, 1.2 crore, 84 lakh become 168 crore, 1.68, 120 become 240 and all. And in the given case, 12 become 24, 17 become 34, 24 become 48. By passing a special resolution. Sir, we wish to increase even more remuneration, sir. Where are you? You are in loss, and according to the maximum limits, you have exceeded the limits, and by passing a special resolution, you are taking double remuneration. And in spite of that, you even want more remuneration. It is possible, but you need to take the CG approval. Who is CG? Central government approval. In general, central government will not allow for that case, but may allow, it may not allow, depends on it. Depends on case to case. Say for example, there is a company and that company is a sick company. Sick and suffering with losses from past 7 years, 8 years, like that. And in order to revive that company, one person who is having enormous amount of expertise in this revival has been appointed as director in that company for the revival of that company. Okay, but that person is demanding more and more remuneration beyond these limits. Now we can approach CG for the approval. In that case, the CG may give approval. Why? Because it is for the best interest of the company only. So like these cases, CG may give approval. But you are the reason for these losses, and now you are asking approval for incremental remuneration. Then what might the outcome of CG? Rejection. Central government may not give suitable approval for you to increase the remuneration beyond 2x. Beyond 2x. Are we clear? This is section 2 limits. Section 2 limits. But I have clearly told you that in section 2 there are two items, two lists, list A, list B, or item A, item B. Nothing doing. We can call it as list or we can call it as item. Anything is okay. So list A, list B, or item A, item B. Limits for item A and item B same. List A, list B same. No change in the limits. You can relax. No more sublimits or no more further limits. Limits for the two lists or two items are one and the same only. But list A directors and list B directors are different. List A directors and list B directors are somewhat different. Sir, what is the difference between list A directors and list B directors? Listen carefully. List A directors and list B directors, we have to check 4 points. I will quickly tell about those 4 points. Yes, I have written here. These are the 4 points. These are the 4 points. If you are able to satisfy these 4 points, you will fall under list A. You will fall under list A. If you are unable to satisfy any of the given 4 points, you will fall under list B. Sir, what is the difference between list A and list B? Listen carefully. Listen carefully. In order to give remuneration to list B directors, in order to give remuneration within the limits only, I am not exceeding the limits. That special specified limits is there, 60 lakhs, 84 lakh, 120 lakh, like that limits are there. For list B directors, in order to give that bare minimum remuneration also, special resolution is required. Which resolution? Special resolution is required. Why, sir? Why? You are going to understand now. Listen carefully. Read out these 4 points. First point is not related to promoter or director. If you are able to satisfy all these 4 points, you will fall under list A. You are not related to promoter or director means you are working in professional capacity, right? You are working in professional capacity. You don't have any pecuniary relation with the company. You are just a director. You have the proper qualification and expertise. You are working as director, simple. Say for example, after completion of CMA final, you got placed in Deloitte. Are you going to become the owner of Deloitte? You are just an employee of the Deloitte. What is the pecuniary relation between Deloitte and you? No pecuniary relation, just employer-employee relation is there. Are you holding more than 0.5% of shares in Deloitte? Or is there any pecuniary relationship, or you have any direct relationship with promoter or directors? No. So first point is that director should not be having any sort of relationship with promoters or directors. And second one, that the director should not hold more than 0.5% of shares. 0.5% of shares, and the director having qualification and expertise for that role and working accordingly. And the company has no default in respect to banks or financial institutions or debentures or debenture holders or to creditors. If the 4 conditions are satisfied, if these 4 conditions are satisfied, watch only these 4 points. Don't read another, don't read the below mentioned theory topics. You will tend to confuse. Simple. I am going to impart the subject in a clear way on your minds. Okay, so listen carefully. So if a director satisfies these 4 points, it means he is just an employee. He is not going to have any sort of pecuniary relationship with the company. Then he will fall under list A. And in order to give remuneration to list A directors, ordinary resolution or simply board resolution is enough. Why? Because directors appointed by board resolution, no, it is enough to give remuneration. No more permissions are required. No more permissions are required. Why? Because which case we are discussing, ma? Section 2, right? Section 2 means company is in losses. Whenever the company is in losses, we have to accountable some persons, right? If directors are taking credit for the profit, they are equally responsible for the loss also. That is why we are segregating directors into two lists. Directors who are responsible for this loss and directors who are not responsible for this loss. List A directors are directors who are not responsible for this loss. In simple, we can conclude like this. Sir, how can you say that those directors are not responsible? This is they are not related to promoters, or they are not having any pecuniary relation. They are holding less than 0.5% of shares and they are doing this job. Why? Because they have proper qualification and proper expertise. And there is no default in creditors or debenture holders or banks or financial institutes. Those directors will fall under list A. And if any of the mentioned conditions has been satisfied, those directors will come under list B. So listen carefully. First 3 points we have to check from director level. First 3 points we have to check from individual director level. But the fourth point we have to check from company level, not from director level, from company level. Understand carefully. Crucial understanding, sensitive understanding is very much important because you are in final level. These are the complicated points. First 3 points we have to check from which individual point of view, or the director point of view. But the fourth point we have to check from company point of view, not from director point of view. We don't need to check whether the director is owed to company or whether director owed to bank or financial institute. Have nothing to do with it. That is his personal. You have to check the company level disqualification with respect to fourth point. Company should not be there should be no default subsist with respect to company payment of bank, loan, financial institute, debenture or creditors. That is fourth point. If these 4 points are satisfied, those directors will come under list A. If any of the mentioned conditions are dissatisfied, those directors will come under list B. What will happen if fall under list B? What is going to happen if directors fall under list B? There is a restriction. What is that restriction? In order to get your remuneration, special resolution is required. Sir, I know this point. Special resolution is required, but not for this point. If we wish to increase by 2x, if we need to double the remuneration, then special resolution is required, not for this point. No, that is the Confucius point. Now, 2 special resolutions are required for list B directors. For first special resolution is required for getting normal remuneration, and another special resolution is required for getting 2x remuneration. And if you wish to get more than 2x remuneration also, CG approval is needed. Which approval is needed? Clear? So this is all about list A directors and list B directors. Now, if we carefully read out our handwritten notes, we are going to complete the entire session with respect to remuneration. Completed. Okay, lot of sublimits and lot of crucial points are there. That is why in yesterday's session also I have clearly told you that these sessions are going to make a difference in your coaching. Your attention is utmost needed. Your active participation is needed in this kind of sessions. Regular session you may listen or you may not listen, it makes no difference. You may listen afterwards also. But these are the complicated points. We have to discuss in a clear and beautiful way. Then only you will be able to understand the subject and digest the subject. Okay. So this is all about the remuneration. Let's quickly recap remuneration. Just a minute. Remuneration. Don't try to tell the answers, just try to recollect the subject. If you try to participate and tell the answers, you will tend to confusion. Just try to participate along with me and try to recollect whether you are going to remember the whether you are going to recollect the subject or not. Just check that point only. First of all, there is a schedule called Schedule 5. In Schedule 5, two parts are there. Part 1, Part 2. Forget about Part 1 now. We'll discuss about Part 2 right now. Part 2 talks about remuneration. But in Part 2, two sections are there. Section 1 talks about company has adequate profits to give the remuneration. Then what are the limits? And we can increase the limits by passing completed. Enough. 11%, you know, right? 11% for all directors. 5% for a single person. If there is a single person as MD or single person as WTD or single person as manager. 10% multiple persons. If there are multiple persons occupying the positions of WTDs and manager, MD as well as like that. Okay. And the third case, 1% and 3% are there, right? 1% and 3% sublimits are for non-executive directors. 1% if there is MD or WTD or manager. 3% if there is no MD or WTD or manager. Clear? Clear? Next one. Schedule 5, Part 2, Section 1 completed. Section 1 talks about companies having adequate profits. Now, we'll quickly discuss about Section 2. Section 2 talks about companies in losses, companies not having adequate profits to give the remuneration. In Schedule 2, Section 2, there are two lists. List A, List B, or Item A, Item B. You can pronounce it as list or item, it makes no difference. But Act contains sometimes, majority times, item A, item B. We can call it list or item, no difference. Okay. What is the major difference between list A and list B means? In list A, directors who are working under professional capacity will be levied in list A. Directors who are working in professional capacity, it means they are not having any sort of relationship with the promoter or director, and they are not holding more than 0.5% of shares, and they are working with qualification and expertise. And the company level point, if the company is not default in payment of dues to banks, financial institutes, creditors and debenture holders. If the 4 points are satisfied, those directors will fall under list A. List A. We can give remuneration to list A directors according to effective capital method. According to effective capital method, and we wish to increase that remuneration, we can do so by 2x by passing a special resolution. So listen carefully. For list A directors, remuneration we can give through ordinary resolution or board resolution. Why I am talking about ordinary resolution? If the director may be appointed in general meeting. Why board resolution? If the director is appointed in board meeting. Okay, if remuneration, if you need to increase by 2x, which resolution is required? Special resolution. Are we clear? Are we clear with this two resolutions? Again, I am going to tell you, listen carefully. Schedule, section 2 talks about companies which are in losses. If you are unable to understand the subject right now, listen carefully. Section 2 talks about companies which are in losses. Companies which are in losses. Out of that section 2, there are two lists or two items. Item A talks about directors who are working in their professional capacity. They don't have any interest in the management. Right. So, if you are willing to give remuneration to that kind of directors, you can give remuneration by simply following board resolution or ordinary resolution. Why I am talking about two resolutions? Board resolution or ordinary resolution? Why? Because their appointment may be done in general meeting or may be done in board meeting. If their appointment is done in board meeting, we have to follow board resolution. If their appointment has been done in general meeting, we have to follow ordinary resolution. Clear? If you are giving remuneration with respect to the given limits, 60 lakhs, 84 lakh, 120 lakh, like that, BR or OR is sufficient. Sir, I wish to increase it by 2x, sir. Yes, you can do so by simply passing special resolution. By passing, sir, I wish to increase even more beyond 2x, sir. You have to take CG approval. You have to take CG approval. Sir, is central government is going to allow me to pay more than allowed limit, sir? Nobody knows. Even central government also don't know. It may give approval or may not give approval. Clear? List A clear? List A clear? Everybody. Schedule 5, Part 2, Section 2, List A. Clear? What is List B? What is List B? Directors who won't fall under list A will come under List B. There is no specific definition for List B. There is no specific definition for List B. Directors who won't fall under List A category will come under List B. Clear? It means directors who have relation with the company. Directors who are holding more than 5.5% of the shares. Directors who are not qualified enough for the job. Directors who have not experienced well enough for the job. That means there is something garbage is there. Then genuinely speaking, they are not eligible for the remuneration, right? And the company is in losses also. They are not eligible for remuneration, right? That is why in order to give remuneration for those kind of directors, we need special resolution. Are we clear? Why we need special resolution for simple payment? I am not talking about 2x limit. I am not talking about incremental limit. I am talking about just plain remuneration. For plain remuneration also, you are going to need special resolution. Why, sir? Why? Because you might be the responsible person for this kind of losses. Sir, how can you say like that, sir? You are not qualified enough. You have no expertise. You have some peculiar relationship with the directors and promoters. So something is there. That is why you might be responsible. Sir, I am not responsible, sir. How can you say allegations on me, sir? On me, sir, like that. Then convince members. If you really don't have any sort of relationship with the laws, members will accept for your remuneration, right? So that is why special resolution is required. Which resolution? Special resolution is required. Clear? Everybody? Sir, I wish to increase remuneration 2x, sir. Again, special resolution is required. Sir, I wish to get even more remuneration even after increasing 2x, sir. CG approval is needed. But generally, CG won't give at this case. For list B directors, generally, there is no hard and fast rule that central government should not give permission. Central government might give permission or not give permission. Depends on central government. This is all about remuneration with respect to list A as well as list B. Section 1 clear amma. 11, 10, 5, 1, 3. In section 2, there are some sublimits. That is why we need to calculate first of all effective capital. Effective capital means paid up share capital plus reserves and surplus, securities premium, loans, debentures, deposits more than 1 year, minus investments, minus preliminary expenses, minus accumulated losses. It will come under effective capital. If your effective capital is negative to 5 crore, eligible remuneration is 60 lakhs per person per annum. Per person per annum. That is executive person. If non-executive person, by 5. 60 by 5, how much? I have already clearly mentioned here. This one, okay. Negative to 5 crore, 60 lakhs. Executive person, 12 lakh, non-executive person. 5 crore to 100 crore, 84 lakh. Executive person, 17 lakh, non-executive person. 100 crore to 250 crore, 120 lakhs. Executive to 24 lakh, non-executive. Sir, beyond 250 crore is my capital, sir. 120 plus 0.01 percentage of paid up share capital greater than 250 crore, 24 lakh plus 0.1 percentage of paid up share capital beyond 250 crore. These limits are equivalently applicable for list A as well as list B. No difference, limits are equivalently applicable. But resolutions vary. For list A, ordinary resolution is enough. But for list B, special resolution. But for incremental 2x remuneration, both cases special resolution is required. If you wish to get even more beyond 2x, CG approval is needed. Clear? I can proudly say there is no video in YouTube or entire social media with respect to explanation of remuneration to directors. I can proudly say I have watched all the faculty videos. They might give proper explanation in their regular coaching also, but I am not expecting. Why? Because they have uploaded the regular coaching videos only, not marathon videos I am talking about. If you even watch any prominent faculty videos, I don't want to take any names. I'm not saying I'm great person, but clarity among the subject is very crucial with respect to these sensitive topics. Why? Because examiner will try to test you from this kind of sensitive and complicated areas only. You are studying final. There is no more point beyond the final. You are not studying foundation or inter. Understanding these kind of sensitive topics with utmost attention is very much needed. You can find n number of videos, but everybody is saying a different topic, different point. What is the actual standard? Your book as well as Companies Act. You won't believe, around 6 to 7 hours I have invested 6 to 7 hours understanding with respect to according to latest notifications and all, according to Companies Act latest amendments. Why? Because law is a vulnerable subject. It will keep on changing. If I have studied 2 years ago, 3 years ago, that provisions may enough or may not enough for current discussion. But I should not guide you in a wrong way. For that purpose, I have referred n number of videos as well as n number of references with respect to amendments as well as Companies Act amendments also. I have invested around 6 to 7 hours time. Not by watching faculty videos, by watching amendments, etc. This is the crystal clear concept with respect to remuneration. With respect to Schedule 5, we can talk about like this. Schedule 5. How many parts? 2 parts. Actually, Schedule 5 Part 2 has Section 3 also. which talks about holding company and subsidiary company remuneration. But no need as of now. Section 1 and section 2 are enough. Okay, so let's quickly read about 826. 4 minutes is there. Let's quickly read about handwritten notes. Yes. This is remuneration, right? I think you have all understand with respect to remuneration, right? If you read these handwritten notes, you will get the clarity with respect to remuneration. First of all, remuneration, schedule 5, part 2. Part 1 talks about part 2, section 1, section 2. First, section 1. What is the case? Adequate profits. Pay according to section 197. 197 means these limits. So what is the first limit? Maximum. There is single MD or WTD or manager. Multiple persons. Non-executive director, no MD. Non-executive director, MD is there. Limits can be increased by passing. Why? Profits are there, sir. Ordinary resolution is enough. No more complication. Special resolution, central government permission not required. Just OR is enough. That is section 1. Let's talk about section 2. Section 2 talks about no profits case. Item A, item B, or list A, list B. Item A means working in professional capacity. Sir, what is meant by working in professional capacity? This means working in professional capacity. First one, not related to promoters, not holding more than 0.5, having qualification and expertise, and company has no default with respect to banks, financial institutes, debenture holders and creditors. That is list A. Sir, if I fell under list A category, then follow effective capital mechanism, and effective capital means paid up share capital plus security premium plus loans, reserves and surplus minus investments, not inventory. You will tend to confuse. At a later point of time, you will read out like the inventory, investments. Next, losses and preliminary expenses. And after the calculation of effective capital, we have to check the slabs. Negative to 5 crore, 60 lakhs, 12 lakhs. 60 lakhs for executive, 12 lakhs for what is PPPA? Per person 84, 17, 120, 24, 120 plus 0.1. How these limits are arrived? Divide by 5. Next one, if item A condition does not satisfy, will fall under item B. What will happen if you fall under item B? For normal remuneration also, you have to convince shareholders and you have to get a special resolution for your remuneration. Listen carefully. Item A, within limits, BR is enough or OR is enough. Beyond limits, SR is required. And maximum with how much extent you can increase that limit? Only 2x. If you wish to get more than 2x, CG approval is needed. Now, item B, SR is mandatory for getting normal remuneration also, along with prior approval from, if the company made default with respect to the payments to banks, financial institutes and debenture holders and creditors, they have to convince them also. You have to take the approval from banks, financial institutes, debenture holders and creditors also. And for 2x limit, they have to pass another special resolution, and more than 2x limit, they have to take CG approval. This is the whole concept with respect to Schedule 5. Actually, Section 3 also I can tell. What is Section 3 talks about? If you are a director in holding company and subsidiary company, you can't get more remuneration than the specified limit. What is the specified limit? Here it is. This is a specified limit. I will give you an example and we'll close this discussion. Section 3 talks about holding company, subsidiary company. Actually not needed. Listen and forget. No problem. X is a director in A Limited, B Limited. A Limited is a holding company, B Limited is a subsidiary company. And both are in losses. Both are in losses. And Mr. X is one of the director in A Limited, B Limited. Both are in losses, right? Now, in order to get the remuneration, you can't get more remuneration than the specified limits. For that, you have to calculate EC, effective capital for A Limited, and EC for B Limited. Say for example, EC for A Limited is 72 crore and EC for B Limited is 2 crore. EC for A Limited 70 crore means which slab? Second slab. Second slab means how much remuneration? 84 lakh. EC for B Limited is 2 crore, which means first slab. That means maximum remuneration 60 lakhs. So 60 or 84. So listen carefully. 60, right. This is 84 lakh. This is 60 lakhs. Whichever is higher. Which figure is higher? So now Mr. X can't get more than 84 lakh salary from A Limited as well as B Limited. He should not get more than 84 lakh salary from A Limited plus B Limited. He can't get more than that. Sir, out of 84 lakhs, 2 companies are there. How we will distribute, sir? Depends. Depends on X and A Limited and B Limited. It means, sir, 42 lakhs by A Limited and 42 by B Limited, or 80 by B Limited and 4 by A Limited. Sorry, 80 by A Limited and 4 by B Limited. It's up to them. Don't get that kind of headaches. Act is saying you can't get more remuneration than the specified limits. That is what Act is saying. How much should be given by this company and how much should be given by that company? It's none of your business. Clear? Huh? A Limited effective capital is 72 crore means which slab? Second slab. That means max 84 lakhs remuneration. B Limited effective capital is 2 crore means which slab? First slab. That means 60 lakhs. Whichever is higher. 84 or 60, whichever is higher. Whichever is higher. You should not add both 84 plus 60, 144. No, that is wrong interpretation. 84 or 60, whichever is higher. Okay, this is section 3. Actually, this section 3 is not required for you, but as the discussion came, I have clearly highlighted this point. Okay, even though if you forget it, not a big deal. Clear, Amma? So this is all with respect to schedule 5 part 1 and part 2. No leftover points. Yes. (8:34). I'm going to take extra 2 to 3 minutes. Okay, 2 to 3 minutes, please. I'm requesting your good selves to extend another 2 to 3 minutes. You can take the proportionate break, no problem. I'll inform to the management. 30 minutes is your break time. 30 or 45? 20 minutes. No. Class schedule to, you can come by 9:15. No problem. Okay. So listen carefully. Everybody sit properly. Your active participation is much needed right now for coming 2 minutes. That's it. వదలట్లేదురా బాబు వీడు అనుకుంటున్నారు. Schedule 5. How many parts? Part 1, Part 2. Part 1 talks about appointment. Part 1 talks about. So in appointment, what you have learned in Schedule 5 Part 1, there are certain points. 4 points are there. That Coffee POSA Act is there. What is Coffee POSA? Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. As well as first point is there, no imprisonment, not even for a single day, and no penalty for more than 1,000 rupee. And the third point is age. Fourth point is residence. If the person who is intended to act as MD or manager or WTD is in compliance with Schedule 5 Part 1, we have to check, sir, satisfied. You can appoint in either board meeting or in general meeting. Sir, not satisfied. Not satisfied, what we need to do? He is disqualified. No, he is qualified, but CG approval is needed. And with respect to MD, WTD and manager appointment, one form is there, that is MR1. We have to file within 60 days. And with respect to CG approval, there is a form MR2. You have to file within 90 days from appointment. 90 only I have said. 90 days. Okay. Next one. Schedule 5 Part 2. Schedule 5 Part 2 talks about remuneration. Two sections. Section 1. Section 2. In Section 1, company is in profits. Section 2, no profits. 11, 10, 5, 1, 3. 3 or 1, 1 or 3, whatever it may be. If you wish to increase, you can do so by simply passing ordinary resolution. Being there is no profits in Section 2, it will be listed into two categories. Item A, Item B. Item A means directors who are working in professional capacity. That means genuine directors. Genuine directors. That is why for Item A, Item B, limits are same. But in order to give remuneration for Item A or list A director, special resolution is not required. Just ordinary resolution or board resolution is enough. But in order to give Item B, remuneration to Item B director, special resolution is required. Sir, I wish to increase the remuneration for both Item A and Item B. You can do it so by passing special resolution, and the maximum limit is 2x. Maximum limit is, even after 2x you can give, but after CG approval. What are the limits? You have to calculate effective capital. Effective capital means paid up share capital plus reserves plus securities premium plus loans, debentures, deposits more than 1 year minus preliminary expenses minus accumulated losses minus investments. This comes to effective capital. If effective capital is negative to 5 crore, 60 lakhs for executive per person per annum and 12 lakhs for non-executive. 5 crore to 100 crore, 84 lakh per person per annum executive and 17 lakh non-executive. 100 to 250 crore, 120 lakhs per executive per person per annum executive. 24 lakh non-executive. Beyond 250 crore, 120 lakhs plus 0.01 percentage of paid up share capital beyond 250 crore. Here 24 lakh plus 0.01 percentage of paid up share capital beyond 250 crore. This is the summary of our last 2 sessions discussion. That is the power of slow and steady discussion. I can complete this discussion by 10 to 15 minutes also, but it will be a Malayalam cinema without subtitles. And a Guruvayar appane. So no one will understand anything. So even if we take some much more time, clarity among the subject and command over the topic is very much needed. Okay. I won't preach anything right now, being you are in very hurry to go and eat breakfast. You can go right now. Let's end up this session and we will meet either Monday or Tuesday. Most probably Monday we will be having our session. Okay. Right. Thank you and all.